Gentlemen, thank you for coming out on a Sunday morning quite so early. I personally found it quite a challenge this morning, so thank you for getting here for this time. I would like to introduce our panel here today for Fighting for New Laws. Obviously, one of the most important parts of the whole topic that we've been discussing and hearing about over the weekend. I look forward to hearing some of the ideas coming from this table. Ben Emmerson, who thankfully most of these people don't need very much introduction because they're all very well known in their field. And I will ask each of them, because I am standing in for Laura Flanders, who is a much better presenter and understands all of these things than me. But Ben Emmerson is the UN Special Rapporteur on Terrorism at the UN and has a vast biog, which you will have seen on your sheets of paper there. I'm going to let Ben tell you anything else that he wants to tell you about himself. Gavin Miller, equally eminent and a friend of CIJ.
Chair of CIJ.
Chair of CIJ and friend of CIJ. I think both things are allowed.
You have to be one to be the other. Right?
Thank you for clarifying that. Carly Nist, I'm sure, again, you will introduce yourself, and Carrie Schenkman, US lawyer. Involved with Julian Assange's case most recently. So without any further waffling from me, I'll hand over to Ben to start off what will be a very interesting session. Thank you, Ben.
Thank you very much, Sarah. I approach this, as you will probably have gathered, from, first of all, a UN perspective, that's to say a global perspective, rather than the legislation or practices or programs enacted or applied by any individual state. And I approach it specifically from the position of the International Covenant on Civil and Political Rights in Article 17, the right to privacy. As probably most of you know, in December of last year, the General Assembly of the UN adopted Resolution 68/167 on the right to privacy in the digital age. It was a resolution co-sponsored by 57 member states and adopted without a vote. In that resolution, the General Assembly affirmed, which is actually rather an important principle, that the right to privacy in Article 17 must be protected online, and called upon all states to review their procedures, practices and legislation related to communications, surveillance, interception and collection of personal data, emphasizing the needs for states to ensure the full and effective implementation of their obligations under international human rights law. That set in train a flurry of activity at UN level, and in June of this year, in accordance with the mandate given by that resolution, the High Commissioner for Human Rights submitted her central report to the General Assembly and the Human Rights Council, and I submitted my most recent report on the 23rd of October, which looks at the counterterrorism justification for internet mass surveillance. The central message of that report is the not very staggering proposition that mass surveillance of the internet, or bulk access to digital communications traffic, as the authorities prefer to describe it, poses a direct challenge to an established norm of international law. States' obligations under Article 17 of the International Covenant include the obligation to respect the privacy and security of digital communications, and that implies, in principle at least, that individuals have the right to share information and ideas with one another without interference by the state, secure in the knowledge that their communications will be read by and will reach the intended recipients alone. Measures that interfere with that right, for those of you who are not lawyers, must be authorized by a provision of domestic law that is accessible to the public and precise, and that conforms with the requirements of the covenant. That means that it must pursue a legitimate aim, and that it must meet the tests of necessity and proportionality. Now, the growth in states' technological capabilities over the past decade has improved the capacity of intelligence and law enforcement agencies to carry out targeted surveillance of suspected individuals and organizations. And counterterrorism is the, if you like, paradigm justification. It's that justification which is most frequently advanced by proponents of greater internet penetration by states, and it is the justification against which, at its outer extreme, proportionality and necessity fall to be judged. There's no doubt, of course, that the prevention, suppression, and investigation of acts of terrorism amount to a legitimate aim for interfering with privacy rights under Article 17. Terrorism can destabilize communities, it can threaten social and economic development, it can fracture the territorial integrity of states, and it can undermine international peace and security. Under Article 6 of the Covenant, states are under a positive obligation to protect citizens and others within their jurisdiction against acts of terrorism. And one aspect of that obligation is the duty to establish effective mechanisms for identifying potential terrorist threats before they have materialized. And states discharge that duty through the gathering and analysis of information by intelligence and law enforcement agencies. Why particularly terrorism? The enhanced capacity of states to monitor internet traffic is said by state authorities to be of particular significance in the counterterrorism context because communications via the internet have played an important part in the financing and preparation of acts of international terrorism, and because the internet has been used for the purpose of recruitment to terrorist organizations and for disseminating terrorist propaganda. The prevention and suppression of terrorism is therefore regarded universally within the UN as a public interest imperative of the highest importance and could, in principle, provide an arguable basis for mass surveillance of the internet. But the intelligence agencies must still comply with international human rights law, merely for them to assert, as a number of the service chiefs in this country and in the US have done since the Snowden allegations, that mass surveillance technology can contribute to the suppression of terrorism, does not provide an adequate international law or human rights law justification for its use. The fact that something is technically feasible and that it may sometimes yield useful intelligence doesn't by itself mean that it is either reasonable or lawful. There's a crucial distinction for the purposes of Article 17. States now have the capacity to conduct targeted surveillance of known and pre-identified individuals and organizations using a wide variety of technical sources. But targeted surveillance, where an individual or organization is already the subject of inquiry, depends on the existence of a prior suspicion against the targeted individual or organization. And it is the almost invariable practice of states to require some form of prior authorization, whether it's judicial or, as in the United Kingdom, executive. And in some states, there is an additional tier of review after the event. But at least where targeted surveillance is in issue, there is an opportunity for an objective assessment to be made of the legality and proportionality of surveillance by reference to the facts of an individual case in advance, measuring the degree of the intrusion against the anticipated value that the information may have to an investigation. But as we all now know, some states have the technology to secure bulk access to communications and content data without prior suspicion. And despite the fact that the focus has been on the US and the UK through Snowden's revelations on the NSA and GCHQ, be under no illusions that those are the only two states conducting this type of mass surveillance. Russia, China, Israel, France, as well as the Five Eyes community and others are states that we know have these capacities, and it is very likely that other states have them too. The authorities in states operating this type of program are now able to apply automated data mining algorithms to dragnet a potentially limitless universe of communications traffic by placing taps on fiber optic cables through which the majority of digital communications travel. These states have been able to conduct mass surveillance of content and metadata, providing intelligence and law enforcement agencies with the opportunity to monitor and record not only their own citizens' communications, but also the communications of individuals located in other states. This capacity is typically reinforced by mandatory data retention laws in many parts of the world that require telecommunications and internet service providers to preserve communications data for inspection and analysis. The use of scanning software, profiling criteria, and search terms then enables the relevant authorities to filter vast quantities of stored information in order to identify patterns of communication between individuals and organizations. Automated data mining algorithms link common identifying names, locations, numbers and IP addresses, and look for correlations, geographical intersections of location data, and patterns in online, social, and other relationships. In that way, states with high levels of internet penetration can gain access to the telephone and email content of an effectively unlimited number of users and maintain an overview of internet activity associated with particular web pages or addresses. And all of that is possible without any prior human suspicion related to a specified individual or organization. It's no exaggeration to say that the communications of literally every internet user are potentially open for inspection by intelligence and law enforcement agencies in the states concerned. And that amounts to a systematic interference with the right to respect for the privacy of communications and requires at the least a correspondingly compelling justification if it's going to meet the requirements of international law. And that's where the counterterrorism justification is said to come in. But the important point for the purposes of Article 17 is that mass surveillance without prior suspicion involves no target-specific justification. And it's therefore going to be incumbent on states who are seeking to justify these measures as proportionate to justify not an individual interference by reference to the facts of a particular investigation, but rather to justify the general practice of seeking bulk access to digital communications on a wholesale scale. The scale of the interference with individual and collective privacy rights of all internet users clearly calls for a competing policy justification of analogical magnitude. As an absolute minimum, Article 17 of the Covenant, which is the equivalent of Article 8 of the European Convention, requires states using mass surveillance technology to give, as a baseline, a meaningful public account of the tangible benefits that are said to accrue from its use, because without a public justification, there is simply no means to ensure or measure the compatibility of this new practice with the requirements of the International Covenant. And yet the reality is that no state has so far provided a detailed, calibrated, evidence-based justification for the scale of the interference involved in the programs that are currently in use. An assessment of proportionality involves striking a balance between the societal interest in the protection of online privacy, on the one hand, and the undoubted and unquestioned imperatives of effective counterterrorism and law enforcement on the other. Determining where that balance is to be struck requires an informed public debate to take place within and between states. The international community, which is now grappling slowly and behind the curve with the development in this technology, now needs squarely to confront the revolution that is necessarily taking place in our collective understanding of the right to privacy. Because any assessment of proportionality has to take full account of the fact that the internet now represents the ubiquitous means of communication for many millions of people around the world. Anyone who wishes to participate in the exchange of information and ideas in the modern world of global communications is nowadays obliged to use transnational digital communications technology. The use of mass surveillance programs of this kind undoubtedly, in my view and in the view of the Office of the High Commissioner, impinges on the very essence of the right to privacy of online communications. It is potentially inconsistent with the core principles that states should adopt the least intrusive means available when entrenching on protected human rights. It excludes any individualized proportionality assessment before an intrusion takes place, and currently is hedged around by secrecy claims that make any form of proportionality analysis extremely difficult. There are no limits to the categories of persons who may be subject to surveillance, and there are no limitations on its duration. Crucially, the states engaging in mass digital surveillance have so far failed to provide any detailed or evidence-based public justification for its necessity, and almost no states have enacted explicit domestic legislation to authorize its use. That state of affairs, should it remain the position, comes close to derogating from the right to privacy altogether in relation to digital communications, without any state having lodged a relevant instrument of derogation. For all of those reasons, mass surveillance of digital content and communications data, at the very least, presents a serious challenge for what is an established norm of international law. It is simply incompatible with existing concepts of privacy for states to collect all communications or metadata all the time indiscriminately. The very essence of the right to privacy of communications is that infringements must be exceptional and must be justified on a case-by-case basis. There may be, as I said earlier, a compelling counterterrorism justification for the radical re-evaluation of internet privacy rights that these practices necessitate. But the arguments in favour of what amounts to a complete abrogation of the right to privacy on the internet have not been made by the states concerned and have not been subject to informed scrutiny or debate. The central recommendation in the report that I put before the General Assembly in October is that states should revise and update domestic legislation to ensure consistency with the right to privacy in Article 17. But more specifically, that since these programs involve interference with the privacy rights of the entire digital community, nothing short of detailed and explicit primary legislation should suffice. Not generic enabling powers, but powers which are spelt out in terms and which involve clear transparency about the degree of internet penetration that a state is engaged in on behalf of its citizens. A public legislative process, that is to say, debates within national parliaments, provide an opportunity for governments to be transparent about their methodology and to seek to persuade their public of the justification for what it is that they are doing. It also enables the public to appreciate the balance that is being struck between privacy and security in their name. The way forward is certainly new laws at a national level, and indeed from the UN's perspective, that is a necessary next step. But one of the questions that people always ask me, and I'll just throw it out at this point and perhaps we can pick it up later, is there any potential for an international agreement or treaty in this field to regulate internet governance, given that the nature of surveillance is transnational in character? The short answer to that is no. It is almost inconceivable that we will reach a point where there is sufficient consensus internationally to move forward with a treaty that's of any meaning or indeed any other form of international agreement. But what we do have, for what it is worth, and it's an extremely valuable technique and tool for campaigning organisations, is a commitment amongst a large number of member states, roughly 60, to keep this issue at the very top of the international agenda at the UN. So we had the process kicked off, as I said, with the resolution in 2013. Immediately on the back of my report and the High Commissioner's report, Germany and Brazil have sponsored another resolution for the Human Rights Council, which is aimed to keep the matter at the very forefront of international debate. But the work in the end that needs to be done in order to bring some form of accountability to this process is going to happen within a national or regional framework. And we're going to hear in just a moment how some of those steps have been taken. But that means politically, it means raising public awareness, it means events like this, it means films like Citizen4, it means getting people interested and supportive behind campaigns, it means getting people to realise that privacy actually matters. And of course, it means also the litigation, which is being conducted with varying degrees of success on both sides of the Atlantic and in the European Court of Human Rights. So I'll give way now to the next speaker who can elucidate some of those issues.